I want to talk to you about your experience with handling principal financial appeals. And these appeals happen more often than not. Well, first of all, they're required if someone has a group disability policy.
Right.
And they're optional usually if somebody has an individual disability policy.
Yeah.
But when it comes to filing a disability appeal with Prudential, I want to talk about why it's so important to get it right. I also want to talk about how we help claimants to file these appeals and why we're doing what we're doing in anticipation of a lawsuit down the road. Because we often tell our claimants, we obviously want to win the appeal, but the better you do in the appeal, the better chance you have of winning your lawsuit. Because there are people who call us and say, look, I already did my own appeal, I want you to file a lawsuit. And we'll do that, but it's a lot better if we've done the appeal already. So start off by talking about, in your experience of working with Principal, first of all, what the typical denial letters look like and what your plan is as a general, because obviously you have a specific plan for everybody, as to what needs to be done to win a principal appeal.
Okay, so the usual appeals, denials that we see are based on, change in definition. Sometimes, goes from can you do your own occupation to the definition of disability changes to can you do any gainful occupation. A lot of times we'll see denials based on that reason alone. Or if it's, a limitation like a 24-month mental health limitation where they've approved and paid you for 24 months under mental health, but you have a physical disability and you got denied. There's a lot of reasons why we see denials. So mainly in these denial letters, they have a paper review done by their peer review physicians that they hire that are going to review your medical records and just disagree with your treating physicians who say that they believe that you can't work based on your medical conditions, whether it's mental health or physical. Their peer review doctors review it and they say, well, we disagree. We don't believe that your restrictions and limitations are as severe as your doctor is claiming, or we believe you don't have restrictions and limitations. We believe you could sit for longer periods of time than your doctor's saying. We believe you could stand. We believe that your condition is not as severe as you claim. So this is where we jump in, because once that claim is denied, in order to get you paid again, we have to do one of two things. We need to win your appeal or win in court. So with Principal, you get one shot at an appeal. So this is for group policies. So we can talk about that right now. So with a group policy and with a denial, you have a mandatory appeal that you have to file. You cannot go to court without doing this internal appeal. You get one shot at it, and like you mentioned before, if the appeal is denied, you can't add anything else. The administrative record is closed. So that means once you get to court, whatever's in that administrative record, whatever was submitted with the appeal, whatever doctor's records you got in there, whatever other information, that's all a judge will see. So the benefit of hiring a lawyer to do your appeal is that we do these all the time. We know what a judge is looking for. We know what Principal is looking for. So we know how to load up your administrative record with evidence that will prove that you're disabled. Now, will this 100% guarantee that Principal overturns the appeal and puts you back on claim? Not necessarily. Sometimes we can file the best appeal in the world and Principal still doesn't want to pay, but what it does is it gives you a better shot, a much better shot of winning your case in court, or getting a good settlement from Principal because they know that they have a good chance of losing. So like you mentioned, getting an attorney in the beginning is much more beneficial, because if you call us in the 11th hour after you've done your appeal already and you've thought you've done a good appeal, meaning somebody says, oh, I wrote a letter and I refuted what they said in the letter, but they didn't add additional medical evidence, we will have additional testing done. We work with the doctors to prepare reports, to write things in certain ways that will get the insurance companies to say, oh, we need to overturn this. So we've been doing this for many years. We know what to look for. So it is much better to have an attorney do that appeal for you, because obviously you'll have a better chance of getting the appeal overturned plus winning in court. And we do look 10 steps ahead, because we have to realize that we can't win every appeal, even though we win a lot. If we're not winning the appeal, we're going to, do a good job for you in front of a federal judge. So
yeah, I always try, as I'm listening to you talk, I'm thinking in my mind, like, when we're talking to someone who's never been through this, we're like seeing, it's like a person who's like going to go on a journey, who's done the journey already.
Right.
And they know the whole road, but the other person's never done the journey. So you're
Right.
trying to think like, well, I want to take you to all the hot spots, because in your mind, you're looking ahead and you're seeing it all.
Yeah.
So when we're talking to a claimant and we're trying to explain this appeal process and keep it simple for them, we're not just thinking about the immediate appeal that we're going to write. We're also thinking about the judge who's sitting down and is going to read this, about how's the judge going to look at it. And we're also thinking about what are we going to put in there that's going to guide the insurance company to find the way we want,
Right.
but not put it in such a way that we're giving the insurance company the opportunity to basically write another denial letter that's going to make it super hard to win a lawsuit.
Right.
And so that's a challenge. And I often tell potential clients when they claimants when they contact us to say, there's an art to writing these.
Yeah.
There's a few lawyers around the country that truly specialize in doing this like we do. But this is not about throwing a bunch of case law at them, telling them everything that they did wrong. This appeal has to be artfully drafted in such a manner to get the facts in that are most important to win, so that no judge could look at this and basically say, I find that it's reasonable that the insurance company denied this claim.
Right.
Or the judge looks at this and says, how could anyone find that this person is not disabled?
Right.
Like, so it's very, very fact driven, and because of our years and years of doing this, we know how to work with the claimant's doctors. We know how to work with outside experts. We know how to work with physical therapists or physical medicine rehabilitation doctors who do functional capacity examinations or neuropsychological examinations, and also recommending what I call forensic testing, which is going to be like, the doctor is going to be like, I know what's wrong with you.
Right.
But there's other types of medical tests which get into when we talk about that subjective versus objective, to say, look, if you go for this nerve conduction study test, or other types of tests, it's going to provide more objective evidence. We know you don't need it. We believe these two fingers are numb.
Right.
But this test may confirm that you have an ulnar neuropathy or something like that. Now, if you have that, disability company, because they're black and white, they're just like looking to check the box and say, okay, that's there, we're going to support.
Right.
So tons and tons of things we can do, lots of options for people, but I like people to understand what the appeals, like you said, there's only one bite of the apple. We can't stress that enough, because how often does someone from not just Principal, but all of these disability companies say, well, just go ahead and write us a letter, tell us why you disagree, and we'll have someone else review it. Yes, but this isn't like at a restaurant, send the manager over, I didn't like my burger and we'll make you a new one.
Right.
This is like, yes, they have to have someone else review it by law, and that person's going to review it, but if you don't give them something absolutely super strong and convincing, they're not going to review the earlier employee from the same company that just denied your claim. So.
Right. No, they would prefer that you don't hire a lawyer, that you write a one-page letter and submit it.
So, well, thank you for sharing your thoughts specifically about these appeals. One of the things we do that's great for potential claimants out there is we always offer a free consultation and review of your disability denial. So feel free to reach out to Rachel or myself. We never charge any fees or costs unless we win your appeal, and we're available to help you no matter where you live in the country.